The non-institutional correction definition of terms. Number 1. Absconding petitioner. A convicted accused whose application for probation has been given due course by the court but fails to report to the parole and probation office or cannot be located within a reasonable period of time. Number 2. Absconding probationer. An accused whose probation was granted but failed to report for supervision within the period ordered by the court, or a probationer who fails to continue reporting within a period ordered by the court, or a probationer who fails to continue reporting for supervision within and or whose whereabouts are unknown for a reasonable period of time. Number 3. The pre-board summary. This document is prepared by the institutional parole officer. Number 4. Absolute pardon refers to the total extinction of the criminal liability of the individual to whom it is granted without any condition. It restores to the individual his civil and political rights and remits the penalty imposed for the particular offense of which he was convicted. Number 5. Conditional pardon. It serves the purpose of releasing through executive clemency a prisoner who is already reformed or rehabilitated but who cannot be paroled because the parole law does not apply to him. Number 6. Pardon. A form of executive clemency granted by the President of the Philippines as a privilege extended to a convict as a discretionary act of grace. Number 7. Amnesty. It is an act of sovereign power granting oblivion or a general pardon for a past offense and is rarely, if ever, exercised in favor of a single individual and is usually exerted in behalf of certain classes of persons who are subject to trial but have not yet been convicted. Number 8. Parole. The suspension of the sentence of the convict after serving the minimum term of the intermediate penalty without being granted a pardon prescribing the terms upon which the sentence shall be suspended. Number 9. Probation. A disposition under which an accused after conviction and sentence is released subject to conditions imposed by the court and to the supervision of a probation officer. Number 10. Board. Refers to the Board of Pardon and Parole. Number 11. Carpeta. Refers to the institutional record of an inmate which consists of his mittimus or commitment order issued by the court after conviction and others. Number 12. Commitment order. Refers to the act of sending a person to prison by means of such warrant or order. Number 13. Caseload. Shall not be assigned more than 10 at any time. VPA shall not receive any regular compensation but entitled to travel allowances allowed under existing government rules and regulations. Number 14. Certificate of final release and discharge. A document issued to a parolee when the maximum period of his prison term has expired. Number 15. Civil liability. The probationer is not exempted from the legal effects of his punishment upon final discharge. Number 16. Commutation of sentence. Refers to the reduction of the duration of the prison sentence. Number 17. Continuance of sentence. A number of courts followed a practice similar to suspension but fundamentally different. Number 18. Cost per day. The average total cost of having an inmate for 1 day of the year. Number 19. The day treatment facilities. Community-based non-residential programs for sentenced individuals, both juvenile and adults. Number 20. Counsel or defense counsel. Lawyer of the petitioner. Number 21. Dead time. A period during a sentence in which an inmate ceases to receive credit for the time he or she normally could be serving. 22. Reprieve refers to the deferment of the implementation of the sentence for a while. It does not annul the sentence but merely postpones or suspends the execution. 23. Parole. Parolee refers to a prisoner who is released on parole. 24. Petitioner refers to the prisoner who applies for the grant of executive clemency or parole. 25. Probationer means a person placed on probation. 26. Probation aides are citizens of good standing in the community who volunteer to assist the parole and probation officer in the supervision of a number of probationer and parolees in their respective communities. 27. Probation officer, a public officer who investigates for the trial court a referral to probation, supervises a probationer, or does both. 28. Parole officer refers to either the provincial or city probation office directed to conduct investigation or supervision under referrals as the case may be. 29. Pardonee refers to a prisoner who is released on conditional pardon. 30. Client refers to a parolee or pardonee who is placed under supervision of a probation and parole officer. 31. Release document refers to the conditional pardon or absolute pardon issued by the President of the Philippines to a prisoner or to the discharge on parole issued by the board. 32. Parole supervision refers to the supervision or surveillance by a probation and parole officer of a parolee or pardonee. 33. Summary report refers to the final report submitted by the probation and parole officer on his supervision of a parolee or pardonee as basis for the latter's final release and discharge. 34. Progress report refers to the report submitted by the probation and parole officer on the conduct of the parolee or pardonee while under supervision. 35. Infraction report refers to the report submitted by the probation and parole officer on violations committed by a parolee or pardonee of the conditions of his release on parole or conditional pardon while under supervision. Number 36. Executive clemency refers to reprieve, absolute pardon, conditional pardon, with or without parole conditions and commutation of sentence as may be granted by the President of the Philippines. Number 37. Probation order refers to the order of the trial court granting probation. 38. Post-sentence investigation. This is the vehicle used to find out the petitioner's legal qualifications and his suitability for probation. It is also used in establishing the diagnosis for his favorable response to the community based on individualized correction program. 39. Sentence. In law, the penalty imposed by the court in a criminal case against a person known as the accused who is found guilty of committing the crime charged. 40. Amicus curiae. A friend of a court, one who assists the court by furnishing information or advice regarding questions of law or fact. A parole and probation administration official. 41. Recognizance. It is a mode of securing the release of any person in custody or detention for the commission of an offense who is unable to post bail due to subject poverty. 42. Waive means to voluntarily give up or relinquish a right, privilege, or claim. 43. Quorum. A majority of all the members of the board shall constitute a quorum. 44. Remission. The President may prevent the collection of fines or confiscation of property. 45. Sanctuary. A city or a region or church where state agents were forbidden to enter for purposes of arresting the accused. 46. Supervision. The continuing relationship between the probationer and the probation officer. 47. Warden. Refers to the officer in charge of the provincial, city, or district jail. 48. Fine. An amount given as a compensation for a criminal act. 49. In bank. Refers to a session in which all judges of the courts participate in the hearing and decision-making process rather than the usual panel of judges. 50. Director. Refers to the director of the Bureau and Bureau of Corrections.